Hello, wonderful audience. Thank you for choosing to spend your time with me. Greetings, explorers of knowledge. Join us as we embark on a quest to understand incorporation business. Incorporation is the formation of a new corporation. The corporation may be a business, a non-profit organization, sports club, or a local government of a new city or town. Now, let's delve into the intricacies of in the United States and explore its various aspects. Specific incorporation requirements in the United States differ on a state-by-state basis. However, there are common pieces of information that states require to be included in the Certificate of Incorporation: License, Purpose, Corporation Name, Registered Agent, Inc. Share par value, number of authorized shares of stock, directors, preferred shares, officers, legal address. A business purpose describes the incorporated tasks a company has to do or provide. The purpose can be general, indicating that the budding company has been formed to carry out all lawful business in the region. Alternatively, the purpose can be specific, furnishing a more detailed explanation of the products and the services to be offered by their company. The chosen name should be followed with a corporate identifier such as Corp. Inc. or Company. A preliminary name availability search is advisable prior to the submission of the Articles of Incorporation. In the case of online incorporation, the state will have the final say with regards to the name chosen for the company. The name shouldn't deceive or mislead consumers. Registered agents are responsible for receiving all legal and tax documentation on behalf of the corporation. Share per value refers to the stated minimum value and generally doesn't correspond to the actual share value. In reality, the value of a share is based on its fair market value or the amount a buyer is willing to pay. An Inc. stipulates the exact number of shares the corporation is willing to authorize. It is mandatory for every corporation to have stock. If the corporation is willing to permit both preferred as well as common shares of stock, then this should have a mention in the Articles of Incorporation, along with the voting rights information. Generally, preferred shares provide its shareholders preferential payments of distribution of assets or dividends, in case the company shuts down its operations. A lot of small business owners only allow shares of common stock. As we embark on the next leg of our journey, let's unpack the layers of legal benefits and examine its core elements. There are a number of legal benefits that come with incorporation. One significant legal benefit is the protection of personal assets against the claims of creditors and lawsuits. Sole proprietors and general partners in a partnership are personally and jointly responsible for all the legal liability of a business, such as loans, accounts payable, and legal judgments. In a corporation, however, shareholders, directors, and officers typically are not liable for the company's debts and obligations. They are limited in liability to the amount they have invested in the corporation. For example, if a shareholder purchased $100 in stock, no more than $100 can be lost. On the other hand, a corporation corp. or a limited liability company LLC may hold assets such as real estate, cars, or boats. If a shareholder of a corporation is personally involved in a lawsuit or bankruptcy, these assets may be protected. A creditor of a shareholder of a corporation or LLC cannot seize the assets of the company. However, the creditor may be able to seize ownership shares in the corporation, as they are considered a personal asset. In the United States, corporations can sometimes be taxed at a lower rate than individuals. Also, corporations can own shares in other corporations and receive corporate dividends 80% tax-free. There are no limits on the amount of losses a corporation may carry forward to subsequent tax years. A sole proprietorship, on the other hand, cannot claim a capital loss greater than $3,000 unless the owner has offsetting capital gains. A corporation is capable of continuing indefinitely. Its existence is not affected by the death of shareholders, directors, or officers of the corporation. Ownership in a corporation or LLC is easily transferable to others, either in whole or in part. Some state laws are particularly corporate-friendly. For example, The transfer of ownership in a corporation incorporated in USDE is not required to be filed or recorded. As we embark on the next leg of our journey, let's unpack the layers of legal history of incorporation in the United States and examine its core elements. Legal opinion on corporations has evolved significantly throughout history, and Supreme Court cases provide a means to observe this evolution. While these cases may seem arbitrary and decontextualized when examined individually, when viewed successively and within historical context, a narrative emerges that offers an explanation for why such views are upheld. Moving forward, we'll be taking a closer look at Trustees of Dartmouth College v. Woodward, 1819. In 1816, the New Hampshire state legislature passed a bill intended to turn privately owned Dartmouth College into a publicly owned university with a board of trustees appointed by the governor. The board filed a suit challenging the constitutionality of the legislation. The suit alleged that the college enjoyed the right to contract and the government changing that contract was not allowed. Chief Justice John Marshall delivered the majority opinion and affirmed that the right to contract exists between owners of private property rather than between a government and its citizens. The case was the first case in U.S. history that asked fundamental questions about corporate entities and the protections they enjoy. It also was a precedent-setting case in extending individual rights to corporations. Get ready for an enlightening exploration as we dig into Santa Clara County v. Southern Pacific Railroad, 1886, and understand its role in the broader context. The railroad was an expensive multi-year project that greatly changed and altered both the physical and commercial landscape of the country. As with most new technology developments that have a broad impact, there are disputes about how those technologies and the businesses they thrive in fit under the umbrella of laws that govern regulations and taxation. In 1886, one such taxation dispute arose between Santa Clara County and Southern Pacific Railroad. The railroad thought the tax code was misapplied to some of their property and assets. In deciding the case, a unanimous court ruled that governments must abide by the same tax code enforcement for individuals that it did for corporations. While not explicitly stated in the case, it was implied that this case extended equal protection rights to corporations under the 14th Amendment. As we enter this new chapter, let's navigate the complexities of Liggett v. Lee, 1933, and unravel its multifaceted nature. The booming economy the railroad corporations helped build from the late 19th into the early 20th centuries came to a screeching halt in 1929. The Great Depression, as it came to be known, helped a view of corporations emerge that put them at odds with the normal working man. The election of Franklin D. Roosevelt was a manifestation of many populist sentiments the country might have felt. In 1933, a Florida case came before the court, again disputing taxation. In Liggett v. Lee, the court ruled that there could be a corporate tax, essentially saying the structure of business was a justifiably discriminatory criterion for governments to consider when writing tax legislation. This was a unique ruling handed down during a unique time in U.S. history that denied a corporation freedom it sought in the courtroom. In this chapter, we'll be shedding light on First National Bank of Boston v. Bellotti, 1978, and its role in shaping our understanding. From 1940 to 1990, the percent of total GDP made up by financial service professionals increased by 300%. Along with that growth, there was a growth in the profits this industry experienced as well. As the disposable income of banks and other financial institutions rose, they sought a way to use it to influence politics and policy. In response, Massachusetts passed a law limiting corporate donations strictly to issues related to their industry. The First National Bank of Boston challenged the law on First Amendment grounds and won. First National Bank of Boston v. Bellotti allowed business to use financial speech in political causes of any nature. In this part of the video, we'll be delving deeper into Citizens United v. FEC 2010 and analyzing its key components. In 2010, amidst an outpouring of frustration and blame directed at Wall Street, the issue of corporate contributions came before the court again. In Citizens United v. FEC, the court said there was virtually no distinction between monetary contributions and political speech, and because we do not limit political speech unless it is tantamount to bribery, corporations have the right as people to donate unlimited amounts of money to any political cause so long as it is not a direct campaign. Get ready for a captivating exploration as we unravel the layers of steps required for incorporation and their profound significance. The Articles of Incorporation, also called a charter, certificate of incorporation, or letters patent, are filed with the appropriate state office, listing the purpose of the corporation, its principal place of business, and the number and type of shares of stock. A registration fee is due, which is usually between $25 and $1,000, depending on the state. A corporate name is generally made up of three parts: distinctive element, descriptive element, and a legal ending. All corporations must have a distinctive element, and in most filing jurisdictions, a legal ending to their names. Some corporations choose not to have a descriptive element. In the name Tiger Computers, Inc., the word tiger is the distinctive element, the word computers is the descriptive element, and the Inc. is the legal ending. The legal ending indicates that it is in fact a legal corporation and not just a business registration or partnership. Incorporated, limited, and corporation, or their respective abbreviations Inc., limited, corp, are the possible legal endings in the US. Usually, there are also corporate bylaws which must be filed with the state. Bylaws outline a number of important administrative details, such as when annual shareholder meetings will be held, who can vote, and the manner in which shareholders will be notified if there is need for an additional special meeting. Get ready for a captivating exploration as we unravel the layers of taxation and their profound significance. Corporations can only deduct net operating losses going back 2 years and forward 20 years. Now, we shift our focus to reporting after incorporation, a topic that deserves our attention. Assuming a corporation has not sold stock to the public, conducting corporate business is straightforward. Often, it amounts to recording key corporate decisions, for example, borrowing money or buying real estate, and holding an annual meeting. These formalities can often be supplanted by written agreement and do not usually need a face-to-face meeting. Get ready for a thought-provoking discussion as we delve into incorporation in the United Kingdom and its impact on our understanding. In the UK, the process of incorporation is generally called company formation. The United Kingdom is one of the quickest locations to incorporate, with a fully electronic process and a very fast turnaround by the National Registrar of Companies, the Companies House. The current Companies House record is 5 minutes to vet and issue a certificate of incorporation for an electronic application. Get ready for a captivating exploration as we unravel the layers of types of companies and their profound significance. There are many different types of UK companies: public limited company PLC, private company, limited by shares, limited company, limited by guarantee, unlimited company, limited liability partnership LLP, community interest company, industrial and provident society IPS, Royal Charter RC. In this part of the video, we'll be delving deeper into Europe and analyzing its key components. In Germany, Austria and Switzerland, the Gesellschaft mit beschränkter Haftung, meaning limited liability business association, as well as the EG Aktiengesellschaft, meaning business association with shares, are the entities most similar to the corporations in the US. In the United Kingdom, with the exception of an unlimited company or corporation which requires no designation as part of its legal company name, the titles limited company, CIC, CIO, or public limited company are used for corporations or their Welsh equivalents in Wales. In France, Switzerland, Belgium, and Luxembourg, the term SARL, company with limited liability, or SA, anonymous corporation, or SAS, simplified anonymous joint stock corporation, is used. Spain, Portugal, Romania, and Latin America use the title SA Anonymous Partnership for stock corporations, all to limited or limited liability for limited companies. LTA is denoted SL in Spain for Sociedad Limitada and SRL in Argentina for Sociedad de Responsabilidad Limitada. In Poland there is the title SA standing for Spółka Akcyjna, Polish for Stock Partnership for Stock Corporations or SP. ZOO Spółka Zagraniczna Odpowiedzialności, a partnership with limited liability for limited companies. There is also Spółka Komandytowa SP. K, a partnership where at least one partner is fully liable and other one has limited liability, and Spółka Komandytowa Akcyjna SP. Kelvin, a partnership where at least one partner is fully liable and other one is a stock shareholder not being liable. Denmark and Norway use the title as for stock corporations, while Sweden uses the similar AB. Finland uses OI for stock corporations, Osakeitai, Julkinen, and Avoinnitai or Komandiitai for private enterprises. Italy uses STO or Società Responsabile Limited to limited liability company, and SPA or Società per Azioni stock corporation. Slovakia and the Czech Republic use SRO, meaning business with limited liability, and AS, meaning business with shares. In Latvia, the most commonly used title of a corporation is SIA for limited liability company, or LLC, and as for joint stock company, or JSC. The title SIA and AS are put before the name of the corporation. Lithuania uses UAB for limited liability company and AB for joint stock company, and, like in Latvia, they also appear before the corporation's name. Bulgaria, Serbia, Croatia, Bosnia and Herzegovina, Montenegro, North Macedonia, and Slovenia uses DOO or. In Cyrillic Serbian and Croatian, Drufusa Agraninem Arjavanu, Macedonian. The only difference is in Bulgaria, where it is reverse, OOD Bulgarian, Romanization, Družistvo s ograničenou odgovornost. It also can be used for limited. UK Albania uses SHIP for limited liability company, SHA, meaning anonymous partnership for stock corporations. Pursuant to the Albanian legislation, the possible business structures are sole proprietorship person, physical business owned and managed by one individual who is personally liable for all business debts and obligations. Limited liability company LLC, a hybrid legal structure that provides the limited liability features of a corporation and the tax efficiencies and operational flexibility of a partnership. Corporation, a legal entity owned by shareholders. Non-profit, an organization engaged in activities of public or private interest where making a profit is not a primary mission. Some non-profits are exempt from federal taxes in the Netherlands. ND namloos vennootschap and BV besloten vennootschap met beperkt uitsprekelijkheid are used. In Belgium, the abbreviations NV and BV or BV, resulting the New Belgian Code of Companies and Associations, are used for similar types of entity. The spotlight now falls on Asia as we delve deeper into its details. In India, the term limited is used for a company that is private, an entity similar to an LLC in the United States. Limited is used for publicly listed companies. Shares of a listed company are traded on the stock market, or a public corporation, a similar entity to a corporation in the US. Indonesia uses PT, meaning private limited, which is the equivalent of an incorporated entity in the US. This legal title is stated in front of the corporation name. If the shares become publicly listed for trading in stock exchange, it is called TC, appended after the corporation name. China uses WFOE or WOFE to refer to wholly foreign-owned enterprise WFOE. This is the most popular form of business entity for foreign investors wanting to set up a company in China. It is a limited liability company. Malaysia uses SN, but meaning private limited, which is the equivalent of an incorporated entity in the US. Singapore uses PT, limited, meaning private limited, which is the equivalent of an incorporated entity in the US. Dubai uses LLC to denote a limited liability company. Listed companies use PJSC to denote a public joint stock company. In Turkey, there are two types of companies: joint stock company JSC and limited liability company LLC. 100% foreign ownership of a JSC is legally permitted under the Turkish law. A foreigner who has never been to Turkey can become a shareholder of a Turkish JSC by way of a power of attorney. Limited equity, which stands for limited equity, is a common form to denote limited liability companies. In the Philippines, it uses the terms corporation and incorporated Inc. Similar entity to a corporation in the US. In the next segment, we'll be exploring Canada and its implications for our subject matter. In Canada, the process of incorporation can be done either at the federal or provincial level. Companies which incorporate with the federal government will generally need to register extra-provincially in the province that they elect to do business. Similarly, a provincial corporation may need to register extra-provincially if they are to have offices outside of their home province. Incorporated Canadian companies can generally use either Corp. Corporation, Inc. Incorporated, Incorpor, Limited, Limit, Limited, Societe par actions de régime fiscal, and serif in their name, but this may vary from province to province. Note that there are two government structures operating within Canada. French system is prevalent in Quebec, while the English system is operating in 9 provinces territories. Leave a comment below and let me know what you thought of this video.